Welcome to Floyd Zadkovich's video series. It's exciting to be here. It's been a little while actually since the last video that we've done, and that may be in part because we've been busy, which I suppose is a good thing. But I'm excited to be here today because there's a case that I want to tell you all about, and I think it's interesting and relevant, and it's on a topic that we don't often hear about or deal with, but can be very important when a GA case comes along. And so that's all about general average, GA, general average. And the decision that I want to speak to you about, it went all the way up to the top of the English judicial system, to the English Supreme Court. And it's known as the Longchamp. That's the vessel's name, and it's a general average piracy case, and there are not many reported GA cases, as they rarely go to court, to be honest, let alone go all the way to the top. So for GA aficionados, I suppose I put myself in that category. I'm not sure what that says about me, but there we go. But it's exciting, and it's a controversial decision. Mainly because it rewrites what we thought we knew about substitute expenses. And from a ship owner's perspective, helpfully so. From cargo interest perspective, not so much. I think this is seen as more of an owner's friendly decision. So just general average generally, I'll touch on that before I go into the facts of the case. And it might be useful for those listening who do not deal with GA cases all that often. So general average, it deals with situations when a vessel is faced with a peril of some kind, and a deliberate and reasonable decision is taken by the ship owner or the master to sacrifice part of the cargo or vessel, or to make an extraordinary expenditure for the common safety and for the purpose of preserving property in the common maritime adventure. So jettison cases are the quintessential GA cases, where one party's cargo is thrown overboard to ensure the vessel and remaining cargo are safe. Say, to lighten a vessel through heavy seas. The vessel and remaining cargo interests then chip in proportionately to compensate the party who has lost his cargo. So those are a classic general average expenses. Now in the Longchamp appeal, we are dealing with what have become known as substitute expenses, or deemed GA expenses, under Rule F of the York-Antwerp rules. Those are extra or additional expenses incurred by ship owners to reduce traditional general average expenses, much like claiming the additional costs of mitigation in a damages case. Now, moving on to the facts of the Longchamp decision. The Longchamp was a chemical tanker that was taken over by pirates off the coast of Somalia in 2009. So it does date back to the real height of the piracy problem in the Gulf of Aden. Now, thankfully, piracy has dissipated in that region. Like it's really come down, and that I think is in part due to the use of armed guards on vessels and collective naval efforts, along with increased enforcement on shore within Somalia. But in this case, on the first day that this vessel was seized, a ransom demand was made by the pirates for $6 million. Over the next 51 days, a crisis management team for ship owners negotiated with the pirates, and ultimately a ransom of $1.85 million was agreed and paid, so a saving of over $4 million. Now, during the time of the negotiations, the vessel incurred operating expenses, maintenance of crew, wages, bunker costs, and other OPEX, and those came to about $160,000. So there's no debate that a reasonable ransom, which is paid to pirates, and for me it sounds like an oxymoron, but there's no doubt that such a ransom is considered proper general average expense and is recoverable. However, the key issue in this case was whether owners could seek contribution from cargo interests for their proportion of the negotiating expenses, that is the OPEX, whilst the ransom was being negotiated down. The average adjusters in the Longchamp and the commercial court at first instance decided these negotiation expenses were allowable and recoverable. Cargo appealed and won in the Court of Appeal. Ship owners, then took it to the Supreme Court. And the reasons for the Supreme Court's decision, they are controversial, let's just say. The Supreme Court upheld the original adjustment and reinstated the first instance court decision. Now this decision runs counter to how adjustments have been done on this type of expense, and it opens adjustments for, allowable adjustments for negotiations on repair bills, salvage costs, and it's not only restricted to piracy ransoms. The judgment itself even acknowledged the controversy between the commonly held view amongst average adjusters and legal commentators, and with the Supreme Court's majority view. So the Supreme Court noted that the leading view amongst adjusters was guided almost instinctively by Rule C, the exclusion of delay-related consequential GA expenses. So since negotiation expenses are delay-related, adjusters tended to believe or held the view that they were not allowable. I'm talking generally here. The Supreme Court gave this view short shrift, to be frank. It said that substitute expenses are by definition not actual general average expenses and are only deemed GA expenses. Rule C applies to consequential losses flowing from actual GA expenses, whereas Rule F expenses, those are incurred instead of GA expenses. So Rule C just does not apply to these negotiation expenses. There were two main contentions by Cargo which the Supreme Court focused on. So the first key argument, it was all about whether there needs to be an alternative course of action taken by owners instead of incurring the general average expense avoided, so as to come within Rule F. The court found that ship owners did take an alternative course by incurring OPEX, the operating expenses, instead of paying the original ransom. That was an alternative. In Obiter, Judge Neuberger, in the leading majority judgment, said he was unconvinced that it was necessary to find an alternative course of action so as to come within Rule F. And indeed, he called it, very dangerous to do so. Although he accepted this formed the conventional thinking amongst average adjusters. Now the second key reason or contention raised by Cargo was that the initial ransom demand, that is the GA expense avoided, was too high and was not capable of being paid reasonably. As such, and picking up the language of Rule A, it's one of the kind of the threshold rule in the York-Antwerp rules, Rule A. Cargo said this meant that the GA expense avoided was not in fact GA because it was not reasonable. The court noted this interpretation could lead to very odd results. Cargo's interpretation meant, let me quote this, if a ship owner incurs an expense to avoid paying a reasonable sum, he can, in principle, recover under Rule F. Whereas if he incurs an expense to avoid paying an unreasonable sum, that is a larger sum, he cannot recover. That plainly does not make much sense, and the court held that this does not arise on a reading of the rules. So the court said that the wording of Rule F specifically, another expense which would have been allowable as general average, that wording is a reference to what is allowable in principle under Rule C, and not to using Rule A as the threshold or gateway to get into Rule F. So that cut out the reasonable test entirely. Further, Rule C only deals with the nature of the expense that is allowable under Rule F, and does not deal with the quantum of the expense being allowed. So particularly, as Rule F has its own limitation on quantum, that is, not more than the GA expense avoided. So there's already this inbuilt limitation on quantum, so why does it have to draw it from another rule? That was the rationale. There are other contentions put forward by Cargo. So I think the question now is where to from here? Where do we go? What's the effect of this decision on average adjustments moving forward? Is it limited to its own facts, or does it have more wide-ranging ramifications?